We are all governed by a law called a Civil Procedure Code, which is governing from last probably hundreds, one decade, one century,
Yes.
beyond that.
Yes.
So the new act is Commercial Courts Act, which is exclusively for the commercial courts,
Yes.
the disputes of the commercial
Yes.
in nature.
Anyways, had a court, civil courts, which would consider all these commercial matters as well. So
Correct.
why is it that the legislature thought of a separate commercial court?
All that will be a commercial dispute.
Yes.
But one thing is, there is something called as a specified value here.
Okay.
Specified value should be more than 3 lakh rupees.
Hello friends, this is Advocate Veena Kamath here, practicing advocate, High Court of Karnataka. A very warm welcome to you all to this lecture series presented by Vakila Vahini. So these are the lecture series which are conducted by Vakila Vahini to simplify understanding different fields of law, where we will bring in experts in the field to talk about various issues, different aspects of the legislation, about how one can approach the courts, different types of dispute resolution, and to simplify the understanding of law. So in today's lecture series, we will be talking about Commercial Courts Act. So on 29 January 2015, our Law Commission in its 253rd report submitted a bill which was named Commercial Division and Commercial Appellate Division of High Courts and Commercial Courts Bill 2015. Now this bill eventually becomes an act which we all know as the Commercial Courts Act 2015. So today we are going to talk about why and how this act was made, what is the purpose of this act, what are the different disputes which can be brought before the commercial court, how is this act beneficial for different sectors of the society, be it a layman, be it in a commercial dispute, non-commercial dispute, how do you identify disputes which can be brought before this court, and how beneficial legislation this is to our society. And we're very happy to be presenting this lecture series on this topic with a speaker today, Advocate Prashant Chandra Sir. Advocate Prashant Chandra Sir is a practicing lawyer. He is a visiting faculty at different law schools. He is a trained mediator. He is also the founder of Vakila Vahini. He enrolled in the year 1987. His practice ranges across different district courts, trial courts, high court, Supreme Court, different tribunals. And he is a mediator with the Bangalore Mediation Center, with the pre-institution mediation, which concept has come in the Commercial Courts Act. And he is loved and recognized by different different sectors, which is the clients, the judges and litigants, and even the layman. Today's speaker, Advocate Prashant Chandra, is also the author of the Commercial Courts Act 2015. Today's conversation with Advocate Prashant Chandra will focus on simplifying the understanding of Commercial Court Act and to talk about the practice and procedure and how this legislation can be utilized by one and all. So when you mention about courts, can you tell us in particular about how in our country do these civil courts function?
Civil courts, one who has been infringed of his rights has to approach the civil court. He will have to lodge a case. He has to wait for the number of years. He has to prove his case by producing the documents and also lead evidence, and he is also be subjected to cross-examination. In the end, the judge gives an adjudication, which is called as a judgment. This is the general process.
Yes.
This is about the civil dispute resolution process.
Yes.
Now, coming to the commercial court, since you have also raised about it, the commercial court hitherto was also in the civil court itself.
Yes. Yes.
There was no primary importance to the commercial disputes.
Yes.
Maybe stakes are high.
Yes.
Now the law is amended, or a new law is set up,
Yes.
constituted. New law is brought in, where the civil court cases, insofar as the commercial disputes are concerned, will no longer go to the civil law court. It will go before the commercial court. So the new act is Commercial Courts Act, which is exclusively for the commercial courts.
Yes.
The disputes of the commercial in nature.
So I'll just pause you for a moment here. Now, when you said that there is a different court for commercial matters, Why do you think was it important that there is a separate court only for commercial disputes? Because we anyways had a court, civil court, which would consider all these commercial matters as well. So why is it that the legislature thought of a separate commercial court?
See, we are already 75 years. India is now 75 years. It is a growing country.
Yes.
The economy is growing. Globalization.
Yes.
Privatization.
Yes.
Liberalization. Commercialization.
Yes.
These are leading to people wanting quicker justice.
Yes.
Faster results.
Yes.
Unfortunately, the civil courts, which are already flooded with the normal civil litigation, they may not be able to find time to devote exclusive time for the commercial disputes.
Yes.
Therefore, the Law Commission has suggested, as you rightly pointed out,
Yes.
that a separate court, a separate system, a separate procedure, separate infrastructure is required for dealing with commercial disputes.
Yes.
So that's the reason why they had thought of this, and this is what has been brought in now from the effect from 2015.
Yes.
Where commercial court is also a civil court,
Yes.
but exclusively for commercial disputes.
Yes.
So the commercial disputes will get priority, they get faster justice, they are able to move on.
Yes.
See, finally, economy is also suffering because of the courts. A
Yes.
delay in justice is also causing recession in the economy.
Yes.
So ease of doing business is more important.
Yes.
Even coming to foreigners, it could be foreign direct investment. They all look at our judicial system.
Yes.
So if it is fast and it is able to deliver quicker justice,
Yes.
naturally the courts also will be giving a message that here is in India, we have a justice delivery system which is fast,
Yes.
unlike what it was earlier.
Yes.
So therefore a separate stream,
Yes.
separate setup is made
Yes.
as in the form of commercial courts.
So when you mention that commercial disputes come before the commercial court,
Yes.
can you tell us what do you mean by a commercial dispute? What are the different types of commercial dispute?
Yes, see, the law has been amended in the year 2015. That is to say, the new act has come into effect from 2015.
Yes.
Section 2(1) defines the number of disputes, types of
Yes.
disputes.
Yes.
There are about 22 such disputes.
Okay.
They are the commercial disputes.
Okay.
I would just give you, for example,
Yes.
few of them. See, for example, disputes pertaining to banks, recovery,
Yes.
disputes by a merchant,
Yes.
financier, all that will be a commercial dispute.
Yes.
But one thing is, there is something called as a specified value here.
Okay.
Specified value should be more than 3 lakh rupees.
Okay.
That is to say, if a bank has lent somebody some loan in the form of a loan, and he is due, and the disputed amount, that is to say the amount which he is not paid to the bank, is more than 3 lakh, then it will be a commercial dispute.
Yes.
We have another thing which has to be examined in particularly bank, because DRT, the debt recovery
Debt
framework,
recovery.
also deals with that.
Yes.
There the limit is 20 lakhs and above. So
Okay.
otherwise, commercial, the disputes between 3 lakh to 20 lakh will be a dispute. If
Yes.
it is of the bank,
Yes.
which is a commercial dispute.
Yes.
This is one example.
Yes.
There are many more.
Yes.
The agreements pertaining to franchising,
Yes.
distribution and licensing agreements, management and consultancy agreements, joint venture. We are all very well aware of these joint venture projects.
Yes. Yes.
It could be Government of India,
Yes.
it could be the state government, or any other government having joint venture projects.
Yes.
It could be construction activity. It could be something to do with partnership agreements. It could be partnership dispute between partners. And there are many more like that. Then infrastructure projects,
Yes.
infrastructure contracts, IPR, technology development agreements. All these are now the disputes recognized under the Commercial Courts Act as commercial disputes. So now such disputants cannot go to the civil court. They have to go only to the commercial court because that's recognized as a commercial dispute.
ಹೆಚ್ಚಿನ ವಿಡಿಯೋಗಳಿಗೆ ಪ್ರತಿಧ್ವನಿ ಯೂಟ್ಯೂಬ್ ಚಾನೆಲ್ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿ, ಬೆಲ್ ಐಕಾನ್ ಕ್ಲಿಕ್ ಮಾಡಿ.